So, hey, it is noon, May 31st, day after Memorial Day. Hopefully everybody was fun, safe, and didn't drink too much, but really enjoyed each other's time out there. And hopefully we memorialize, we remembered everybody that's really important, those that we have lost. So here we go. We're going to kick back in. If you can, let me know that you can see my screen. That will be important. Give me a thumbs up. Awesome. Thank you, Yvette. And I'm going to get the admit all in here. And let's see if I can get PowerPoint to function correctly for me. So where we're at, guys, is we are now continuing on from last Tuesday. And you remember that what we had was purchase agreements. The biggie with the purchase agreements is to make sure that we're writing those things in a way that keeps us and our sellers out of trouble. We want to make sure that we're going to avoid anything that could come up. So here's the first one, and you are the co-host, sir, so I'm going to clear this off mine so that you can watch for people coming in. All right, so first question we got for the day. My sellers have a purchase agreement signed with buyer A. So they have a purchase agreement. All of a sudden, along comes buyer B, who has now made an offer on the same property that the sellers consider to be a better offer. Buyer A has proposed an amendment to his purchase agreement, asking to purchase some of the seller's outdoor lawn furniture and pool equipment. So let's generalize this a little bit more to what we're used to. We have an offer to a seller, it's accepted. Purchase agreement probably allowed for other showings and thus other offers that could be accepted. But of course, those have to be subject to the non-performance of the first offer. That first offer the seller is bound to. So they say yes to the second offer, and the first offer comes with a proposed amendment to the purchase agreement. You know, something that we might be more, what's the word, used to would be an amendment based upon an inspection. And then the seller goes, well, wait a minute, I got this other offer. They've just changed the terms of the purchase agreement. I'm going to go ahead and accept this other offer and move it into the primary position. So that's what we're dealing with in this one. A little bit different what they asked for. But again, the sellers want to rescind the purchase agreement with buyer A and enter into the purchase agreement with buyer B. Does buyer A's proposal, so here's the real question of the scenario, does buyer A's proposal of an amendment to the existing purchase agreement reopen the contract such that the sellers may terminate it? And what is the answer to that? I'm going to let you guys think about that. If you're in a group setting, you can talk about it a little bit. I hear a no here. What say you, Mackenzie? No? Correct. It is still a binding agreement. Therefore, the seller cannot move to another purchase agreement. Some realtors have the misconception, and this is the real key. I love the way that this first starts out. Some realtors have the misconception, and if an amendment to an existing contract is proposed and rejected, the purchase agreement is terminated. And that is a false understanding. Ordinarily, this is not the case, and you do have to say that because it does depend upon what the terms of the purchase agreement, how the purchase agreement is written. If a proposed amendment to a contract is rejected, the purchase agreement remains in full force and effect. Remember, it's amendment or addendum. What's the first 5 letters of amendment? Amend. You're amending the contract. To amend it, both parties have to agree to that. addendum, add to the agreement, ADD. So both parties need to agree to make any changes too. But making a proposal doesn't change it in any way whatsoever. Okay. Now, obviously, again, if you were to come to your manager, the first thing you're going to ask for, bring me the purchase agreement and any other paperwork that comes along with that. So good stuff there. Any questions on that one at all? Sounds like everybody's good. All right. Next question. I am a realtor representing sellers on the sale of their house. They entered into a purchase agreement with a buyer yesterday. Today, the buyer's agent called me and said that the buyer wishes to exercise his 3-day right to rescission. So purchase agreement accepted. Sorry about that. They got buyer's remorse and decided they didn't want to buy it. Can they simply state that due to the 3-day right of rescission, we wish to rescind the agreement? Can a buyer do that? Does such a right exist in real estate in the state of Michigan? And I can see those of you showing your lovely faces. No, they cannot. The 3-day right of rescission does not apply to real estate in the state of Michigan. That becomes the bottom line. It just doesn't exist. So if anybody wants to throw you that out to you, your correct response would be, I can appreciate that you'd like to do that. However, you speaking of a 3-day right of rescission on a contract does not exist in Michigan for real estate. Okay. Now, does that mean that we shouldn't talk and try to keep things simple? Look at the purchase agreement. What does it say in regards to inspection? Because all they have to do is to state, well, let me do my inspection. Now I'll tell you I don't want it. That's going to be most purchase agreements. But again, look at the specific verbiage on the purchase agreement. If somebody's going to walk and it's this quick, they're probably going to be able to walk one way or another. But bottom line, work with your manager regarding this situation or circumstance. Next one. I am representing a buyer who has made an offer on a home. The seller countered our offer with a clause stating that the buyer waives his right to inspect the property. Is it permissible? Is it permissible, as you begin your discussions, is it permissible for a seller to make a proposal, a counter offer, or if you will, even to say, I am rejecting your offer, but I'll make an offer back to you that I'll take it with all of these terms, and you have to actually waive your right to an inspection. Can a seller put that proposal out there in a counter offer? What say you? I've got shaking heads here going this way. It is yes. Absolutely. The seller can actually propose anything that they want, as long as it's within all of the rules, regulations, and not prejudicial, any of those other things. So it's as simple as, now that the proposal has been made, the seller or the buyer has to decide whether or not they want to reject or accept. But there's the proposal that I give back to you. See, the buyer made an offer. Seller said no, but I will do this. And it's up to the buyer to decide whether or not they want to go with that. All right. Any questions to that one? Next one. I submitted an offer on a home, and this was done on behalf of my buyer client. The listing agent told me state law requires that a pre-approval letter was necessary in order for an offer to be valid. Is this true? What says ye? Is a pre-approval letter required by state law? That should be your clue that I'm giving you there. Hey, so the answer is yeah, actually, Cameron, you're right. It's great to have. But no, it is not required by state law. See, what we're doing, when we do this on behalf of a seller, when we request the pre-approval letter, we're doing that to minimize the risk of the seller accepting this offer. That's all we're really doing. We're going, does this person, should we accept it, have the opportunity to be able to take care of that? Hey, John, are you watching the chat room too? Just, I see that. Awesome. But we're trying to minimize the risk on behalf of the seller that if they say yes to this offer, that the seller will close as proposed in a reasonable amount of time, okay? When we provide it on behalf of the buyer, we're pretty much doing it for the same reason. We're trying to say that, hey, seller, if you accept our offer, you have minimal risk in accepting it because here is a pre-approval. And of course, we know that the seller's agent having a conversation with the mortgage person can enhance it even further because where are they at in the pre-approval process? There are some lenders out there, and I think they're great to be able to work with, that they may actually be proceeding and you could have a buyer who's approved, fully approved, other than on the purchase, or excuse me, on the home and it meeting the appraisal. Veronica, you got a question out there? I see your hands up. You might have pushed that accidentally. And you're off mute. Okay. If it comes up, Ronnie, let me know. I can see you now, but you are muted again. So jump back in here if you do need, but right now we're not hearing. Okay, I'm going to go ahead and move on. I presented an offer from my buyer. However, the listing agent told me that the offer was not valid since the buyer's signature was not witnessed. And this is actually more common than not. But for somebody to be so bold to say it's not a valid offer because it's not witnessed is kind of interesting. But I think I've probably already given you an indication to what the answer is. Does an offer to purchase real estate require a witnessed signature? And the answer is no. There is no legal requirement for witnessed signatures in a contract for the sale of real estate. What people will commonly look toward is recorded documents. Maybe there are certain things that need a witness and we don't even notice it because when we're sitting there at the closing, the notary, the closer, is stamping and doing the necessary things that may or may not even need a witness signature. But a purchase agreement to be binding requires no witness, not at all. All right, I'm going to assume all things are good there. Question. I am a realtor that just moved to Michigan from another state. The state I'm coming from requires a listing broker to make sure that an earnest money deposit is provided for each transaction. And is this required in Michigan? So this one, we've got a lot that we can expand upon, and we might have a little bit more conversation toward this. But is an earnest money deposit required to create a binding agreement in the state of Michigan? So for those on camera showing yes or no. I've got a no here, a no, and the answer is no. It is not required, but it is done as a matter of custom, and it is a good idea. Matter of fact, how much should we get? You guys can put it in the chat room. I'd be curious to see what everybody's thoughts are toward this. Share your thoughts. Should, or how much should we be getting? Now, I'm going to share the thoughts of $500 is like having no earnest money deposit. Matter of fact, $1,000 is like having no earnest money deposit. If there's ever a quarrel over who should receive that, it is hardly worth it for either party. Now, whoever gave the $1,000, maybe it's going to be worth more to them than it would be to the other party. But when it comes to the point of having to fight or negotiate for that, it's going to be difficult. I can tell you that. After any court costs, and I don't know, maybe we need to talk about how earnest money deposits should be handled in another Hot Topic Tuesday. But if there were a dispute in regards to the earnest money deposit, and it actually had to be taken to court, what is called interpleaded, forced by us to make that happen, or if either party to the transaction decided to file in court, be it small claims, let's call it that, you're talking, John, what we looked at that, it was $750, 500 minimum
To interplead?
to,
Yeah, 750.
to interplead 750. So I think small claims is like 250.
Just to file.
And then you still don't know if you're even going to win. So your 1,000 or your 500 just dropped by $250. So if we're going to make it worthwhile, I'm going to tell you, you ought to look at 1%. Get as much as possible is really the standard, because see, I'm assuming even if I'm working with a buyer, that they're sincere in wanting to move forward. And if you are, then give me a sizable earnest money deposit, one that will help me get your offer accepted, because it's showing the good faith of the buyer in being able to move forward with that. So get as much as possible. Now, another one just came up. Here's a question that's popped. What if it's a cash offer? Either I'm receiving or I'm writing. What should you get? Now, I'll leave you to stew on that for just a couple of seconds, and then I'm going to give my thought. We should do like Jeopardy or something, have that music, right? Yeah. All right. So here's the thought. Get as much as possible. Guys, they're going to put 100%. They've got it. Get as much as possible. So look, it could be 10%. It could be 20%. I one time had the full purchase price as an earnest money deposit, all of $7,500. It was a piece of vacant land back in 1990, sorry, in Muskegon on top of it. But they gave me the whole thing, but they were offering like 30% under what they were asking. So if you want them to say yes to this, give me all the money. All I had to do was get a check from the admin to be able to get it to the closing. And they had to bring a couple of dollars, but that was the simple part to it. We have something in the chat room. The not to exceed. Yeah. So here's the key. If it exceeds your commission, and this is a big note, so if you've not had this yet, you have to remember this. If you take an earnest money deposit that is larger than the commission that we are going to receive, you must get a reimbursement. Gosh, what am I? It's not, I'm not using the right term, John. We've got to get the overage check from accounting. And you're going to want to request this in advance of the closing. I believe we need to be, somebody, if Michelle's listening on, she can jump in, or manager. I believe we need to be about 5 days out. I believe 5 days out. By the way, 1 week in reality, because there's certain people who have to complete that overage check and certain people who need to sign that overage check. So keep that in mind. If you exceed in an earnest money deposit the amount that you are getting or the company is getting as a total commission. And by the way, with that, it's not in this, but if you receive an earnest money deposit, meaning, let me rephrase that. If an agent, any agent receives an earnest money deposit, into whom trust account is that earnest money deposit to go to? It is to go in the broker's trust account. It is assumed that that would happen. And if it is to be different than that, what must happen? So if Joe Schmuck from Schmoes Realty takes an earnest money deposit and Schmoes Realty doesn't have a trust account, but they do it through the title company. This is a common one. What must we do? Or what must that agent do? And this is the realistic one, because we are collecting and we do have a trust account. They are to be given to the admin as soon as you receive it, and it will be deposited at the first possible day. What must we do when an agent states they are not holding the earnest money? It must be stated on the purchase agreement who is actually holding the purchase or the earnest money deposit. So as an example, if I'm at Schmoes, Real Estate, and gosh, I don't know, the Title I is holding the account or holding the earnest money on the purchase agreement, it must state that the earnest money deposit of whatever the amount is being held in escrow at, and state Title I. Okay, so that's a must happen. Oh, you know, I think it's a good one. So the aspect of the personal check. First, what we know is we don't take money. There's an odd one. We don't accept cash. Okay. Oddly enough, real estate's a very important one where we don't take cash. So then it's personal checks, money orders, certified funds, things of this nature. If you get a personal check, know that it is being commingled with other people's money. It is not our money. So to ensure that their money actually went into our trust account, we need that 10 days for that check to clear. We need a verification in 10 days, within the 10 days, that that check is cleared and that their money actually went into our trust account, which has everybody else's money, not our money. So you see, if people ever say, well, why do you got to hold? Why can't you give me my money? Because for 10 days, we don't know that your money is in that account. If we gave you back that money and your money wasn't in that account, guess what? We've just given away somebody else's money to somebody who wasn't there. So if you take a personal check, make sure that they understand that we're going to be holding this for 10 days. And of course, if they're going to buy a house from us, it doesn't matter even if they don't get that first one. All right. Good stuff. Let's see. Any other questions pop up from that, John? And how many more do we have? Do I have more? No, that was the last one. So guys, that's what I've got for today, but I'll leave it open. Do you have any other questions? Pop them up or take yourself off mute.
Michael, can we ask the
Yes.
question? Can you present an offer without an EMD?
Can you present an offer without an EMD? So let me go back. It's a great question, Michael. Let's go back to a previous question. And that question said, is an earnest money deposit required to create a binding agreement? Do you remember the answer to that? Because the answer to that was no. So what you really have is that same thing then, but it's, if it's not required to have a binding agreement, I definitely do not need one just to make an offer. Even in a customary source then, know this. Quite often, we write an offer where it says that the earnest money deposit will be provided within and deposited within so many days of receipt of seller's acceptance. Okay, so we could write that in. And by the way, that's done quite often. My recommendation is do it from the point of seller's acceptance. Did that answer your question, bud?
Yes, but I would like to add another question to it. So would
Okay.
that make the offer more how can I say it? Would that put my offer in a bad position, or would it look bad? Definitely.
Yeah, think of it from the point of the seller. It will be basically a higher risk. They'll see it. Less desirable, and they would probably, well, here, I'm giving no earnest money deposit, or I don't even have it yet, to I've got somebody that gave me a $20,000 earnest money deposit on a $200,000 home. Which one am I going to be feeling a little bit better about?
The one
So it's
with,
from that perspective that we want to see it. Okay, good question.
well, I had a client, Darwin. He wanted to make an offer, and he said, I'm gonna put 40% down. Actually, no, 40,000 down, and the house was 188,000. So he said, I'm gonna put 40,000 down, and I'm gonna offer 158. He said. So
$100,000 down, but is that down or earnest money?
no, he said, I'm gonna put 40,000 down on $188,000 home.
Okay.
And he said, I'm gonna offer 158 as my purchase price. So he basically
Okay.
went more than 30,000 less, and he said, I'm gonna offer the 40,000 down. So what do you think about that offer?
Not a bad offer, quite frankly. It's nothing that I'm going to necessarily get excited about because of the lower value, but anything's possible. Okay.
So question in chat, where'd it go? Question in chat is, I had a buyer with a PA that expired before we were ready to close. We wrote an addendum to PA for time extension. The addendum wasn't signed yet, but no mutual release was talked about, let alone signed by anyone. The house became active on the MLS. It took 3 days to get the seller's agent to give us a signed addendum, which came in last week. The house is still active on the MLS. What should be done?
Call your cousin Guido. That's a great question. First thing I would say is, what's the reason for the delay? That's a key part. I want you all to know this part of it, and I'm going to do my best with my eyes. Paragraph number 7, the closing, it states, subject to all conditions herein, Closing shall take place on or before a certain date. Okay? If any purchase agreement deadline, including but not limited to the closing date, cannot be met due to any government regulation or lender requirement. So this is a big part to your question, Andre. The buyer shall not be deemed in default, and the deadline or closing date shall be extended for the period necessary to satisfy these requirements. The closing will take place at the listing broker, title company, or lending institution. So the reality would be, if it was to either a government regulation or something to clear lending, you didn't even need an extension. Best that we have that, but we didn't even need an extension. We should have been continuing to proceed to closing without any worry about that closing date. Now, that leaves a lot of open for interpretation. But the closing date is not a hard date. But what I want you to see is how the purchase agreement is written. And you will need that in the future. If you haven't run into this, you will need it. And it's really fun to turn to an agent and say, Mr. Know-it-all agent, Miss Know-it-all agent, I'd ask you to take a look at paragraph 7 where it states, and you read that to them verbatim, and then watch them cower or try to defend their undefendable position. Okay, that's a key one. So the bottom line is that I'm going to make sure that they understand. I'm going to notify my broker, my manager, of what's going on and make sure that we send proper communication. But I am stating that Mr. or Ms. Realtor, please be advised that we are moving toward closing and plan to close on or before whatever that date that the lender tells us they're going to be able to make that happen. And yes, still do an addendum to get that extended out there. So great question. Hopefully I answered that. Otherwise, Andre, we'll talk more a little bit later here. All right. All right. So guys, I'm showing 12:32. I went over. I'll slap my hand this time and we'll try to stay better, but that was a great question. It came toward the end. I want to make sure that everybody knows next Wednesday, not tomorrow, but next Wednesday, outstanding speaker with David Knox, going to be with us on June 8th from noon until 1. David is wildly entertaining. He is funny, takes and makes somewhat the complicated to very simple. And just kind of shows us a lot of love in the way that he presents. So he's going to be with us next week in regards to being able to have profitable open houses. So here we wrap up another Hot Topic Tuesday. You guys have a great week. Go be productive.